All right. Since Dobbs overturned Roe, we haven't gotten a lot of good abortion news. Today, we kind of have to, and you'll realize why in a moment. So the first one is the Missouri voters will be able to decide abortion rights in that state. It's going to be on the November ballot. Now, obviously, on face value, that's great. I mean, Ohio is a conservative state, and they enshrined abortion rights. Because, as I mentioned before, this isn't a Democratic issue or a Republican issue. Most people, most women especially, want to have the ability to choose when they have families and under what circumstance, or whether they, want to be alive to raise their other kids and have to make horrible decisions. Because, let's face it, pro-lifers basically treat abortion as if women who have abortions are just going doop-de-doop-de-doo to the corner store and have an abortion. No. Anyway, enough rambling. So, an amendment that would enshrine abortion access in Missouri's Constitution will appear on the state's general election ballot, Missouri's Secretary of State Jay Ashcroft's office announced Tuesday. Ashcroft, a Republican, deemed that the petitions to qualify the initiative for the ballot had the sufficient number of signatures. He also approved other initiatives for the November ballot, including one on minimum wage and earned paid sick time, as well as one on sports wagering. If approved, the initiative would amend the state's constitution to establish a right to make decisions about reproductive health, remove the state's current restrictions on abortion, allow the regulation of reproductive health care to improve a patient's health, and require the government not to discriminate against people providing or seeking reproductive health care. All wonderful measures. Too bad it didn't say about the minimum wage thing. Okay, I assume it's raising it, but to what? That would have been nice to know. All right. The ballot would also protect abortion rights up until fetal viability, around the 24th week of pregnancy, except to protect the life or health of the mother. Hear that, people who claim to actually give a damn about the fetus? And by that I mean the pro-lifers. Your idea that, the fetal heartbeat starts at 6 weeks, which it doesn't. Okay, even if it does, they're not viable till the 24th week. What the hell does it matter? I mean, of course that, past the 24th week, it should be only extreme circumstances. And here's a secret. It is. It's not like someone reaches the 25th week of pregnancy and decides, I don't feel like being pregnant anymore. I think I'm going to have an abortion. Not a thing. So to have that exception is, kind of redundant, because that's generally the only time past 24th week that abortions even happen. All right. The group that spearheaded the ballot measure, Missourians for Constitutional Freedom, had submitted the required number of signatures to officials in early May. The group celebrated the development Tuesday in a post on X, saying that it turned in 380,000 signatures. Now remember, Missouri is a red state. It's a conservative state. This tells you along with Ohio and Kentucky, that the people want to have the choice. Not all these people are saying that they love abortion, they, can't wait to have one, or whatever fantasy you have in your head about people who are pro-choice. This is simply showing you that people understand that sometimes you have to make the hard choices. And it's not for anyone else but the immediate person, their doctor, and whomever else they deem reliable to help them make the decision. Those are the only people who should make the decision regarding abortion. Not some suit, across the country or across the state, depending on what we're talking about, deciding for a woman they've never met what they can and can't do health-wise. Anyway, I am honored to say that it is our turn to do something that no other state has done before. End a total abortion ban at the ballot box, says Rachel Sweet, campaign manager for Missourians for Constitutional Freedom. Which, oddly enough, sounds like something that a Republican group would name themselves. Let's see. This November, Missouri voters will have the opportunity to make their voices heard and return decisions about abortion to their rightful place with women, their families, and their doctors, not politicians. Exactly. It is not anybody else's business. You personally wouldn't have an abortion under any circumstances? Fine, don't have one. Nobody is forcing you. But you don't get to tell other families what they can and cannot do. Because there's all sorts of reasons why women have abortions. And the reason that having the exceptions that a lot of these bans have, well, some of them, is because you can't come up with every scenario. And because you can't come up with every scenario, something is going to go wrong. So how about just not bother? Just let women, allow women to do what they have to do. And, trust women. Women kind of know what they want from their lives. They know what their health is like, whether they can carry a pregnancy to term, whether they can do it health-wise, financially, whether they have kids already and they know that having another one would jeopardize their ability to take care of the ones they already have. There's all sorts of reasons. And I know I didn't cover it all because I'm not a doctor. I don't know all the reasons. Which is why I don't tell women whether they should or shouldn't have an abortion. Not my business. Ashcroft was among conservatives who challenged the group's effort to get abortion placed on the ballot. Of course he was. Missouri has one of the strictest abortion bans in the country, with exceptions to protect the life of the mother and for medical emergencies. Now, like I've mentioned in previous videos, what life of the mother, what does that mean? Does it mean that once a woman goes into sepsis? Does it mean when she's this close to flatlining? Seriously, what does that mean? Same thing with medical emergencies. Okay, so I keep bringing this up. Kate Cox. She had a medical emergency. She had a fetus with a genetic abnormality, which, if she had taken to term, would potentially prevent her from having more children. And then she had to go to the court in Texas and have a bunch of lawyers deem whether this qualifies. Well, okay, even if you have exceptions for this, lawyers should not be the one to decide that this falls under the exception. I mean, they're not doctors. They're lawyers. So they should have absolutely no say in these cases at all. Amendments that would protect or expand abortion rights will also appear on the ballots in 7 other states this fall. Organizers in Arkansas, Montana, and Nebraska have also submitted signatures for similar ballot measures. And yeah, all 3 are red states. So, again, this is not a Republican versus Democrat issue. This is whether you want to treat women as thinking human beings or whether you want to treat them as walking incubators. All right. The efforts come after the U.S. Supreme Court overturned Roe v. Wade in 2022, effectively allowing states to decide whether abortion would be legal. Voters in California, Michigan, Ohio, and Vermont enshrined access to an abortion in their state's constitution since then, while similar measures failed in other states. I thought Kentucky was one of them. Either it failed or I'm misremembering. But anyway, that is the end of that article. So let's go to the second article and second good news. And that is Indiana Attorney General drops suit over privacy of Ohio girl who traveled for abortion. Now, for those who do not remember, let me see if I got this correct because it's been a while. It's been a minute. So, an Ohio girl who, of course, there was an abortion ban. I think she was... Now, I know she was raped. I just can't remember if it was a stranger or a family member. But anyway, she went... I think she was 10 years old at the time. So she went over the border to Indiana to have an abortion. Because, I think it was actually medically necessary. I don't think it was just because she was raped, even though just that would be a great reason. But I think, and then the Indiana Attorney General tried to go after the doctor, saying that she did something wrong with the paperwork or something. It was a mess. But anyway, let's get to the article and see how much I actually remembered. Indiana's Attorney General has dropped a lawsuit that accused the state's largest hospital system of violating patient privacy laws when a doctor told a newspaper that a 10-year-old Ohio girl had traveled to Indiana for an abortion. Which, well, yeah, that doesn't violate privacy laws, okay? You know she's 10 and you know she's from Ohio. Okay, that's totally enough information to find out who she is. Are you kidding me? A federal judge last week approved Attorney General Todd Rokita's request to dismiss his lawsuit, which the Republican had filed last year. Oh, it's only been a year? Against Indiana University Health and IU Healthcare Associates, the Indianapolis Star reported. The suit accused the hospital system of violating HIPAA, the Federal Health Insurance Portability and Accountability Act, and a state law for not protecting patient information in the case of a 10-year-old rape victim who traveled to Indiana to receive abortion drugs. Dr. Caitlin Bernard's attorneys later that she... What? Dr. Caitlin Bernard's attorneys, this is how they wrote it. Later, that she shared no personally identifiable information about the girl, and no such details were reported in the Star story on July 1st, 2022, but it became a flashpoint in the abortion debate days after the U.S. Supreme Court overturned Roe v. Wade that June. A federal judge in Indianapolis initially granted IU Health's motion to dismiss the case in June, prompting Rutica to file an amended complaint in July. His office then sought the case's dismissal last week, writing that the state's initial complaints have been satisfied by actions IU Health have taken since the Star first reported on the girl's case. I wonder what that was. Or they're just claiming that just to, try to preserve some dignity. These actions include continuing to train employees not to talk about patients in public spaces and informing employees that if they are contacted by a reporter, they must inform the public relations or communications department before responding, Rutica's dismissal motion said. So yeah, it sounds like it's just a formality because, again, the doctor did not give any identifiable information. She just said, I did a thing. Okay? I mean, I guess if you looked up her records, the doctor's records, you could figure it out, but yeah, those aren't public records, so you're not going to get that anyway. We are pleased the information this office sought over 2 years ago has finally been provided, and the necessary steps have been taken to accurately and consistently train their workforce to protect patients and their healthcare workers, Roikita said in Monday in a statement. However, IU Health said it has always had such practices in place, and it is disheartened by the claim that those were corrective actions made in response to Roikita's suit. And let's face it, he's just trying to save face. He's trying to back away slowly, realizing he done fucked up, and, just trying to make this as graceful of an exit as he can do. So he can still say that he accomplished something without being seen as a complete and utter prick. IU Health has and will continue to maintain its robust HIPAA compliance policies and training for its team members as it has for years, its statement reads. While we are pleased the Indiana Attorney General's office voluntarily moved to dismiss the case, we are disappointed the state's limited taxpayer resources were put toward this matter after the first complaint was dismissed by the court on the merits, which makes him even more of a prick. I mean, it is obvious that he is pro-life, and he just really, really, really wanted to stick it to this doctor and the hospital she works for in hopes that he will destroy them for daring to perform an abortion. The fact that she actually went to the media and gave any information was just his in. It was just his way of trying to destroy her and the hospital. It had nothing to do with anything else. Oh. Sorry, I had crushed red pepper earlier and it's in my throat now. Indiana's Medical Licensing Board reprimanded Bernard in May 2023, saying she didn't abide by privacy laws by talking publicly about the girl's treatment. All the more reason why this suit shouldn't have gone on as long as it did. It was far short of the medical license suspension Roikita's office sought, and IU Health's own internal investigation found that Bernard did not violate privacy laws. Of course he wanted her license suspended, because she dared to perform an abortion. It had nothing to do with who it was or that she went to the media. He just couldn't stand that an abortion happened. Anyway, the Indiana Supreme Court, meanwhile, reprimanded Roikita and fined him $250 for making statements about Bernard that violated rules of professional conduct for attorneys. $250? Are you kidding me? He's the Attorney General of the state. Do you really think that's going to hurt him? I mean, I don't expect Indiana to be, super rich or anything, but pretty sure $250 isn't going to be a fine that he can't handle. Anyway, that is all I have for this video. And with that, I will see you guys in the next one.